African Revenue Service has approached the Constitutional Court for direct leave to appeal a High Court order compelling it to hand over the former President Jacob Zuma's tax returns for his time as president to two media houses. 2 weeks ago, the Gauteng North High Court in Pretoria ordered Sars to supply investigative journalism site amaBhungane and weekly business magazine, The Financial Mail, with Zuma's tax files for the years between 2010 and 2018. For a reaction on this, I'm joined by Dario Milo. He is a senior partner at Webber Wentzel, a law firm that's representing the applicants. Mr. Milo, thank you for joining us this afternoon. If you could start perhaps by giving us your stance as to the confidentiality argument that Sars is putting on the table.
Yes, of course, and good afternoon to you and to your viewers. The confidentiality argument that Sars puts on the table is a good argument as a default argument. In other words, the general principle should certainly be one of confidentiality, and that's what the media groups accept. This case, though, is really not about that general principle of confidentiality. It's about when an exception should be recognized to that principle of confidentiality. And that's why the High Court judgment was correct, because it recognized, firstly, that there should be an exception to that general principle, and there isn't an exception in our law until the High Court's decision. And secondly, it regulated the circumstances in which that exception arises. So that's my position on the case, of course, acting for the media groups.
And perhaps for the benefit of our viewers, talk us through the exceptions when these would be applicable.
Yes, well, the exception is very well known to our law because it is the exception that already is there in the Promotion of Access to Information Act, in PIA. And this is a PIA case. It's a case where a journalist requested the tax records of the former president under the Access to Information Act, and that was refused by Sars because the Access to Information Act at the moment and the tax legislation has no exception to the general rule of confidentiality. So what that exception would be is exactly, as I say, what it is for all other categories of information that you can request under the Access to Information legislation. For example, national security information, legally privileged information, commercial information, and confidential information. All of that is regulated through this concept of the public interest, and that's where the exception kicks in. In particular, what it would mean is that you would have to show, as the requester, that there is a likelihood that the records you are requesting would reveal a substantial contravention of the law, and that on balance, the records should be made available to you in the public interest. So that's really the content of that exception, and it's not a novel exception, it's one that already applies, as I say, in the Access to Information Act to all the other categories of information.
You've mentioned two key areas here. One being the matter must be of public interest, and I guess the question then is public interest to what end, which you then said there has to be then a possible contravention of the law, and that's why then it is of public interest. How does this particular application differ from the applications that were previously made by the public protector, which were unsuccessful?
It's a good question, and the answer is that the cases are completely different because they approach the issue completely differently. In the public protector's case, she was saying that the Public Protector Act requires her to be able to get access to these records in order to investigate, and that the Tax Administration Act impliedly permits access by the public protector as a Chapter 9 institution. And of course that failed, as we know, at the level of the Constitutional Court. But what the public protector was not doing is she was not challenging the Access to Information Act at all. Hers was not a case under the Access to Information Act. The media's case is a case under the Access to Information Act where they say, we brought this request, but there's a problem with the Access to Information Act. It's unconstitutional to the extent that it doesn't allow for access to these records in the public interest if there is a substantial contravention of the law that can be shown or that is likely to exist. And that's the difference between the two cases.
Could it then be, Mr. Milo, that it is the approach of the public protector that was flawed, that if she had used a different set of arguments and not relied on the Public Protector's Office being able to gain access to those type of records, that the verdict or the judgment in her case may very well have been different had the argument been different?
Well, it's difficult to speculate. I think what the Public Protector might have done or have considered is challenging the constitutionality of the Tax Administration Act and arguing that there should also be an explicit reference to the Public Protector in all the organs of state that SARS is entitled to share tax information with, because, of course, SARS is entitled to share tax information, for example, with the National Prosecuting Authority if there is a potential prosecution of an offence. And I think that might have been a better course of action to adopt in that particular case.
What we've seen is that in law, it's all about precedence. Should this access to the former president's records truly be accessed by the media, does this not set a dangerous precedent as far as people's confidential information then being publicly accessible, opening up floodgates, so to speak?
Well, I think the floodgates argument is wildly exaggerated because, remember, what has to happen here is a court process ultimately before the records are made available, if there's an objection. So if there's a request, as there was here, for the former president's tax records, SARS refused that request, or perhaps President Zuma, he didn't in this case participate, but in another case, another taxpayer might say to SARS, I don't consent to my records being available, and here's why I say so. Then the person who wants access has to go to court and has to persuade a judge that there is a substantial contravention of the law that the records will reveal, and that's why they should be made available. So it's a very carefully crafted set of circumstances, ultimately controlled by the court, which will permit this access. And ultimately, the court, by the way, can always take a look at the records itself in order to satisfy itself that they should be made available to the requester. And that's called the judicial peak, which is very well known in our access to information law. So I don't think the floodgates will open, just as, by the way, the floodgates haven't opened in the area of, say, national security. Because in national security law, there is also this very exception, the exception to allow access to the media or to anyone if they make the request, if there's a substantial contravention of the law.
How is this going to impact journalists in the future who may be wanting to publish sensitive information that they get through, whatever means, information such as a person's tax records? What impact will this particular ruling have on that?
Well, let's be clear about one of the impacts of this decision. It does not say that if a journalist or anyone gets given a brown paper envelope with someone's tax records, they can now publish those records. Absolutely not, even if they are President Zuma's tax records, by the way. Because all it says, that would still remain a criminal offense. It would remain a criminal offense to publish someone's tax information without having gone through the right process. The right process that the judgment recognizes, and I must also stress it has to be confirmed by the Constitutional Court still. So this isn't the case at the moment. It's in limbo, pending the Constitutional Court's consideration of this issue, which will be sometime next year. But the process is this, that if a journalist is leaked information like that, the journalist will have to request it formally under the Access to Information Act and will have to argue, ultimately in court potentially, that they should have the right to disclose. They can't simply, with impunity, disclose the information. That would still remain a criminal defense, and this decision has no impact on that principle.
Mr. Dario Milo, Senior Partner at Webber Wentzel, thank you very much for your time and your insight regarding this matter. They are a law firm that's representing the applicants. As you know, this case has been taken by the South African Revenue Services to the Constitutional Court, and this is following the High Court judgment giving access to 2 media houses to be able to publish the former president's tax statements and returns.